If jurisdiction is the question, proof is the price. What strikes me in modern administrative practice is how often the government starts from an assumption. You are inside the fence. Not because a court made the threshold finding Steele Code demanded, and not because Congress expressly reached your private conduct, but because you, or someone in your chain, filed a registration, accepted a card, clicked an electronic affirmation. The file becomes the fact. The presumption becomes the posture. And if you don't challenge the premise early, the burden you should have insisted the proponent carry ends up on your back. This session from the Jurisdictional House of Cards is about that posture. Jurisdiction by presumption and consent by registration. We are going to take two fresh Federal Register items, not because they are lurid or scandalous, but because they are ordinary. They are the kind of unglamorous notices that actually order the world we live in. First, the Department of Homeland Security's final rule titled Alien Registration Form and Evidence of Registration, FR Doc number 22E6-13057, which operates in the statutory lattice of 8 U.S.C. 1301 to 1306 and 8 CFR Part 264. Second, the Food and Drug Administration's proposed rule on establishment registration and product listing for tobacco products, FDoc number 226-13047, promulgated under the Tobacco Control Act Section 905, codified at 21 U.S.C. Part 387E. Put those alongside the Administrative Procedure Act's rulemaking baseline in 5 U.S.C. per 553, the burden and presumption architecture of Federal Rule of Evidence 301, and two Supreme Court cases, Steele Co. v. Citizens for a Better Environment, 523 U.S. 83, 1998, and Kokkonen v. Guardian Life Ins Co., 511 U.S. 375, 1994. Then ask, who bears what burden and when? I've read these kinds of notices for years, and the pattern is consistent. The preamble declares statutory authority. The regulatory text defines who must register, when, and what evidence counts as compliance. And the paper object or electronic entry you receive becomes a keystone in later proceedings. That is not nefarious by itself. Government can regulate within the powers granted. But the evidentiary effect of your own filings can become the hinge for jurisdictional claims far downstream. In a courtroom, subject matter jurisdiction cannot be conferred by consent. The party invoking federal power must show the hook. Yet in agency practice, your registration often functions as the ready-made hook for administrative authority and, if unexamined, for judicial deference to agency records. Here's the path we'll walk. In the paper trail, I name the statutes, rules, and docket identifiers precisely because this channel lives or dies by the primary sources. Then I draw the public versus private lines that registration regimes trace, and we will test those lines against the basic burdens that Rule 301 and the Supreme Court have drawn. Finally, I hand you a research map, concrete pages to pull, preamble sections to annotate, and questions to ask aloud the next time you see evidence of registration treated as fait accompli. Where law, logic, history, and spiritual truth meet, the light is in the simple disciplines. Read the text, separate presumption from proof, never confuse your private rights with a public license. That is the ethic of this session. Let's earn every claim with paper. Start with the backbone on burdens and presumptions, Federal Rule of Evidence 301. In federal civil cases, a presumption shifts only the burden of production to the party against whom it is directed. It does not shift the ultimate burden of persuasion unless a federal statute provides otherwise. That one sentence is a governor on the engine of administrative presumptions. An agency may call a certificate evidence of compliance or status, but in court the proponent still must carry persuasion unless Congress has expressly altered the rule. Now, anchor jurisdiction, Steele Co. v. Citizens for a Better Environment, 523 U.S. 83, 1998. The court rejected what it called drive-by jurisdictional rulings and insisted that Article 3 jurisdiction be established before the merits. No bootstrapping, no assumed jurisdiction to get to outcome. Close by is Kokkonen v. Guardian Life Ins Co., 511 U.S. 375, 1994, which restated the first principles. Federal courts are courts of limited jurisdiction. The presumption is that a cause lies outside that limited jurisdiction, and the party asserting jurisdiction bears the burden of establishing it. If we do nothing else today, hold those 3 lines in your kit. The administrative baseline is the Administrative Procedure Act's Notice and Comment rubric at 5 U.S.C. 5553. It requires notice of proposed rulemaking, an opportunity for comment, and a concise, general statement of basis and purpose in the final rule. The preamble you read at the front of a Federal Register notice is not operative law, but it is the agency's own statement of authority, need, and response to comments. It is where the agency tells you the jurisdictional story it believes. Now to registration regimes. For aliens, Congress built a detailed structure in 8 U.S.C. per 1301 to 1306. Section 1302 imposes registration duties. Packer 1303 addresses special groups and fingerprints. 1304 speaks to forms, procedures, and evidence of registration, and 1306 codifies penalties for willful failures and false statements. The implementing regulations live in 8 CFR Part 264, titled Registration and Fingerprinting of Aliens. Those regulations define which forms constitute registration, what documents count as evidence, how reissuance or replacement occurs, and increasingly how electronic records function as the government's proof. The DHS final rule identified in FR Doc No. 226-337, Alien Registration Form and Evidence of Registration, is a classic example of regulatory housekeeping with potent evidentiary consequences. In its preamble, DHS will cite its statutory authority, 8 U.S.C. 1103, 1304, among others, summarize comments, and state why particular forms or cards are designated evidence of registration. The codified amendments in Part 264, across sections like 264.1 and 264.5, are the operative text that courts apply. For tobacco establishments, the Family Smoking Prevention and Tobacco Control Act added Chapter 9 to the Food, Drug, and Cosmetic Act. Section 905, codified at 20 U.S.C. Par 387E, requires owners and operators of establishments engaged in the manufacture, preparation, compounding, or processing of tobacco products to register with FDA and to submit product listings. The FDA's proposed rule, FR DACA 2026-13047, titled Establishment Registration and Product Listing for Tobacco Products, sets out definitions, submission mechanics, often electronic, timing, initial, annual, and updates, and the scope of what constitutes a tobacco product for registration purposes. Its preamble cites authority under 21 U.S.C. Par 387E and procedural footing under 5 U.S.C. 553, explains the need for the data, and addresses the Paperwork Reduction Act by identifying OMB control numbers to be sought. Finally, remember a second APA anchor that often gets overlooked, 5 U.S.C. Par 556D for formal adjudications. It states that except as otherwise provided by statute, the proponent of a rule or order has the burden of proof. Whether your case is in a formal APA hearing, an informal enforcement posture, or a federal court on review, that statute, together with Rule 301, Steele Co. and Kokkonen, frames the ultimate burden landscape. Those are the texts. Place the 2 fresh Federal Register notices squarely on the table, spine to spine with the statutes and rules just named. The preamble is the agency's story. The codified CFR text is the binding rule, and the rules of evidence in Supreme Court cases are the fence lines the agency cannot move. Public versus private is not a slogan. It is a posture you inhabit. Registration regimes are designed to convert ambiguity about your status or activity into an administratively legible fact. Once that legibility exists, it becomes the default starting point for subsequent proceedings. The key is to discern what capacity you are in when you register and what kind of jurisdiction is at stake. Consider the DHS rulemaking under 8 U.S.C. 1301 to 1306 and 8 CFR Part 264. Alien registration is not a discretionary license you request to gain a privilege. It is a statutory duty tied to Congress's plenary power over the admission and presence of aliens. In that realm, evidence of registration functions as proof of compliance and as a portable status token that the government may require you to produce. The public capacity is obvious. The registrant is subject to a public law duty created by Congress, and noncompliance carries public law penalties under Trek 1306. From an evidentiary angle, the card or electronic record becomes prima facie proof that a person is within the statutory class and has or has not complied. But even here, Rule 301's discipline matters. If, for example, the government asserts a violation premised on an absence of valid evidence, the ultimate burden to prove the statutory elements of the offense remains with the government. The registrant may bear a production burden when confronted with a lawful request to produce evidence, but persuasion does not silently migrate to the individual by virtue of the agency's label. Shift to FDA's proposed tobacco establishment registration rule under 21 U.S.C. Part 387E. Here, registration is a condition of participating in a regulated commercial activity. You choose to operate an establishment engaged in manufacturing or processing tobacco products. By doing so, you accept statutory responsibilities to register and list products. This is the archetype of a statutory privilege space. Rights attached to persons. Privileges attached to activities contingent on compliance. In this setting, consent is not mystical. It is embedded in the decision to enter the regulated field. FDA can structure submissions, deadlines, and even inspections to the extent Congress authorizes, precisely because you have stepped into a public regulatory framework governing commerce in a sensitive product category. Yet, even here, the agency's claimed jurisdiction over you, your facility, and your products is not self-proving. When the question is whether an activity falls within Part 387E's defined scope, the proponent of jurisdiction, the agency in an enforcement action, must establish those predicates. Your prior registration does not expand the statute. It is evidence that you are in the field. Now stitch in Steele Co. and Kokkonen. Subject matter jurisdiction in federal court cannot be conferred by consent or by the parties' papers. So if an enforcement or review action arises, and a threshold question is whether the court has statutory authority to hear the case, the party invoking the court's jurisdiction must show it. That is distinct from personal jurisdiction, which can be waived or consented to. Agency registration can have the effect of establishing contacts or consent for certain administrative processes, but it cannot manufacture Article 3 jurisdiction in a court that Congress has not endowed with power. Where is the trap? It lies in the glide from administrative legibility to legal conclusiveness. Agencies often describe documents as evidence of status or compliance. Regulated parties then treat those descriptors as if they shift the ultimate burden or as if silence equals assent to every downstream consequence the agency prefers. The APA's structure and Rule 301 disagree. In formal adjudication, 5 U.S.C. Car 5v6d says the proponent of a rule or order bears the burden of proof. In court, presumptions ordinarily shift only production, not persuasion. And in every forum, a foundational principle endures. The one who asserts jurisdiction must prove the hook. So separate the spheres. In the government's public law domain, like alien registration, duties are imposed by statute, and carrying evidence is part of that duty. In the statutory privilege domain, like tobacco establishments, you opt into a regime that conditions the privilege to operate on registration. In both, however, do not let an administrative label erase the burden lines that Steele Co. Kokkonen, Rule 301, and the APA draw. If you want to test this episode's claims, you do not need my adjectives. You need the paper. Begin with the 2 Federal Register notices, the summary flagged. First, pull DHS's Alien Registration Form and Evidence of Registration Final Rule, FR Doc number 226-13057 on the Federal Register website. Read 3 things carefully. The authority citation at the top, note which sections of Title 8C and 6 U.S.C. it invokes. The preamble's summary and response to comments sections. Look for phrases like evidence of registration, documentary proof, and any statements about electronic records, legal effect, and the specific amendments to 8 CFR Part 264. Flag which sections define the form, which define the evidence, and what, if anything, the rule says about replacement, revocation, or invalidation. Then, with the statute open, read 8 U.S.C. 1302, 1304, and 1306 back to back. Ask yourself, where does Congress impose the duty? Where does it speak to evidence? Where does it set penalties? Note the verbs. Second, pull FDA's proposed rule, Establishment Registration and Product Listing for Tobacco Products, FR Doc num 226-13047. Again, work the trifecta. Authority citations, you should see 21 U.S.C. 387 Indian Sea Act cross-references, the preamble's justification of need and data use, Does FDA invoke traceability, surveillance, or supply chain risk? And the proposed codified text. With 21 USC bar 387E open, compare definitions and timing. Does the proposed rule tighten deadlines, mandate electronic submissions, or define establishment scope more granularly than the statute? Note any references to enforcement consequences for noncompliance, and where in the Act those consequences originate, e.g., prohibited acts or misbranding provisions. Third, print Federal Rule of Evidence 301 and alongside it 5 USC 556D. Read them aloud. Then place Steele Co. v. Citizens for a Better Environment 523 U.S. 83, 1998, and Kokkonen v's Guardian Life Ins Co. 511 U.S. 375, 1994 on your desk. In Steele Co., underline the passages that insist on resolving jurisdiction before merits. In Kokkonen, mark the sentences stating that federal courts are of limited jurisdiction and that the party asserting jurisdiction bears the burden. Ask, how do these guardrails apply when an agency relies on your registration as the keystone fact? Fourth, examine the APA's rulemaking baseline at 5 USC Pracker 553, and if either notice cites it, any good cause exceptions claimed or Paperwork Reduction Act discussions. Does the preamble attempt to characterize the legal effect of a registration document beyond what the statute expressly says? If so, where would Rule 301 and 556D cabin that claim in a contested case? Finally, frame 3 hypotheticals to test the analysis. 1. An alien charged under 8 USC Pracker 1306 for failure to carry evidence. What, precisely, must the government prove, and what is the effect if the individual produces an expired or electronic record? 2. A small tobacco processor who failed to complete registration before a product run. What statutory elements must FDA establish to impose sanctions, and does the proposed rule purport to create any presumption not found in TASER 387E? 3. A federal court faced with a government motion that rests on an administrative record of registration, but a contested statutory predicate. How does Steele Co. and Rule 301 structure the sequence and the burdens? Your objective is not to adopt my view, but to triangulate your own by reading the same pages. Spread the light of your divinity. Seek the truth. Law and logic must go.
Free on that long rights them pure. In the courtroom me out secure. Yeah, Jah are the only sovereign. Give me the key. Me stand firm, Jah guide me destiny. Him sovereign, I am me serve. Me live for Jah, I am me preserve. Jah give me wisdom, me not live for man. Me follow Jah command, me life in him hand. Them want take the land, take the riches and gold, but Jah give me the kingdom, my soul them can't hold. Me walking out the light, me can't lose me way.